Hello, my name is Helen Rhodes, and today I am presenting on the topic of international trade law and remedies for contract breach. Established in 1966, the United Nations Commission on International Trade Law is the central legal body of the United Nations system governing international trade law. The Commission specializes in worldwide commercial law, legal and legislative guides, case law and uniform commercial law updates, technical assistance, and provides regional and national seminars. Through legislative and non-legislative means, the Commission plays a vital role in providing the framework for progressive harmonization and modernization of commercial law. These areas include dispute resolution, international contract prices, transport, insolvency, e-commerce, international payments, and secured transactions, and procurement and sales of goods. These channels are negotiated between both member and non-member states and offer solutions appropriate for different legal traditions and countries of different levels of economic development. The United Nations Convention on Contracts for the International Sale of Goods was adopted by the United Nations on April 11, 1980. Its purpose is to provide a modern, fair, and uniform system for contracts involving the international sale of goods. Because the sales contract is at the root of all international trade, it is considered a core international trade law convention. The convention balances the interests of the buyer and the seller. It is especially attractive to smaller and medium-sized companies and traders operating in developing nations who have limited access to legal advice for sales contracts. The convention governs international sales contracts using three key provisions. The first provision is that the sales are private and the company's place of business are in contracting states when the private international law leads to the application of the law of a contracting state and applies to the party's choice. The second part deals with development, offer, and acceptance of the sales contract. The third part of the convention deals with the obligations of the contract. This includes remedies for breach of contract. The 6 remedies for breach of contract as laid out by the convention are taken from civil and common law systems. Contract avoidance occurs when there is a fundamental or substantial breach of the contract on the part of the buyer or seller. This could be because of a defective shipment on the part of the seller or non-payment of goods by the buyer. In cases of avoidance, a buyer may get a full refund of payment, or if the seller does not receive payment for the goods, he may be released from the contract. In case of non-remedy, the seller or buyer may bring legal action. Right to remedy is a concept the convention encourages. This way, the parties can remain in contract by allowing parties time to correct the non-conforming shipment as long as the requirements are met by the contract end date. Extension for performance may be requested when a seller is unable to provide goods within the specified time in the contract. The buyer must accept the request for extension if it is reasonable. Price reduction is another way to remedy the breach of contract for the receipt of unsuitable goods. Monetary damages should be equal the amount of loss only and is considered compensatory damages. Consequential damages can be awarded under special circumstances. Specific performance is a remedy concept in civil law countries. This is used when remedy cannot be satisfied by way of awarding monetary damages and the judge requires a party to carry out the terms of the contract. The convention may grant specific performance whether or not money damages have been awarded. This is difficult to carry out in common law countries such as the United States. Critics of the convention point to Article 25 as being ambiguous as it treats breach as a remedy of last resort. It can be difficult to prove the contract avoidable. Article 25 uses abstract concepts which implies discretion in interpretation by judges and ambiguity of requirements for breach of contract. This may account for a number of countries not adopting the convention. The convention has become one of the most successful legal systems in providing a worldwide uniform commercial law. It has diminished the differences between traditional civil and common law and bridged the gap between developed and undeveloped countries, as well as different economies. Thank you, and I hope you have enjoyed and learned from this presentation.